Angela Herder here.
Yes, Mitchell.
Okay, on the record in the matter of the people of the city of Lansing versus Angela Herder, file number 24-01410, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, carrying on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Herder, who is standing to my right.
Oh. Today was the date that was reset for a pre-trial on a no opt. We gave her 30 days to see if she can get her license. Was she able to do that?
No, Your Honor. She was not able to, Your Honor. There is a holdout of Ohio for an unpaid fine that she's still working on. It's going to take her some time to get that balance completely paid down.
How do you want to proceed?
Your Honor, I have made an offer to amend the driving while license not valid charge to fail to display apps. I'll defer to Ms. Sutter.
That's correct, Your Honor. I have reviewed that offer with Ms. Herder, and she would like to accept it today.
That's correct, ma'am.
Yes.
You raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can put your hand down. Excuse me. So you have the right in this matter to proceed to a trial because you have the right to presumption of innocence. You're innocent until proven guilty. You have the right to require that the city prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. In order for you to plead guilty to no ops, you would need to give up that right. You understand that?
Yeah.
You have to give up your right to see, hear, or question any of the witnesses that they intend to call at trial. You have to give up your right to call your own witnesses to trial or present evidence at trial that you believe show a defense to the charge being brought against you. You give up your right to remain silent and not have silence be used against you. You understand that?
Yes.
Are you willing to give up all of those rights?
Yes.
Is anybody threatening you to do that?
No.
Has there been any promises made in exchange for you entering a guilty plea?
No.
As to the charge of failure to display ops or operator's license, how do you plead?
Guilty.
So because you believe you're guilty?
Yes.
Factual basis.
Thank you. Ms. Herder, on or about May 1st of this year, were you driving a vehicle on or near Pennsylvania and Vine Street? Yes. And is that in the city of Lansing? Yes. Eagan County, state of Michigan? Yes. And at that time, were you driving a vehicle without a valid license? Yes. Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the city?
No, Your Honor.
For the satisfied with the factual basis, I'll accept your plea and find if you make you voluntarily and intelligently. Your fine is $200. And can you pay that?
2 months.
Excuse me?
Can I have payments? I think 2 months.
Okay, how much you gonna pay this month? $50?
Yeah.
On what day?
Friday.
Friday's date is the 16th. So you'll put $50 this Friday, you'll pay $50 the 16th of each month until paid in full. Do you have any questions?
No.
Any additional matters for the record?
Nothing from the city. Thank you.
You're all set. Sorry. She's all set. She said she's gonna do it on Friday. But on the record in the matter of the people of the city of Lansing versus Cary Seabrook, file number 24L2861981, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, carrying on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing today on behalf of Mr. Seabrook, who's joining us via public comment.
Okay, Mr. Seabrook, today's the date set for a pre-trial on this failure to display a valid license. We did adjourn this matter back in June to allow you an opportunity to see if you can get your license reinstated due to a medical suspension. Council, how are we proceeding on this?
Thank you, Your Honor. Mr. Seabrook did not have an opportunity to get his license back. He is still in custody. I have offered to amend the failure to display ops to allowing a suspended person to operate. It is my understanding he intends to accept that offer today.
That's correct.
That's correct, Mr. Seabrook.
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Okay, Mr. Seabrook, in order for you to accept the offer to plead guilty to the amended charge of allowing a suspended person to operate, you would have to understand your rights and then give those rights up. You have the right to the presumption of innocence, so you're innocent until proven guilty. Do you understand that?
Ma'am.
You have the right to a trial and you have the right to jury trial. You have the right to see, hear, or question any of the witnesses that the city intends to call to testify against you at your trial. You have the right to remain silent at trial and not have silence be used against you. You can call witnesses to testify for you at your trial or to present evidence that you believe show a defense to the charge being brought against you. You can waive your silence and testify for yourself at your trial, but you have the right to require the city prove each element of the charge being brought against you beyond a reasonable doubt. And you're willing to give up each of those rights today? You're willing to give up each of those rights?
Yes, ma'am.
Anybody promising you anything to get you to give those rights up?
No, ma'am.
Has there been any threats made to you in exchange for you entering a guilty plea today?
No, ma'am.
As to the charge or the amended charge of allowing a suspended person to operate, how do you plead?
Ma'am.
Excuse me?
Guilty.
Is that because you believe you're guilty?
Yes, ma'am.
Factual basis, counsel.
Thank you. Mr. Seabrook, on April 15th of 2024, were you driving a vehicle on or near South Pennsylvania and Euclid?
Yes.
And is that in the city of Lansing,
Yes.
Ingham County, Michigan?
Yes.
And at that time, did you allow a person without a valid driver's license or a suspended license to drive a vehicle?
Yes.
And that person was yourself?
Yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
City satisfied with the factual basis, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea and I find your plea to be made freely, voluntarily, and intelligently. Your fine is $250. When will you be able to make payment?
Your Honor,
Oh,
this
I
time we
thought,
Excuse me?
I thought I was gonna be getting, time served.
I don't know why you thought that. You are on a PR bond on this matter, so you don't have any time.
I was misunderstood. Okay, I can make a payment whenever I get out. I don't know when I'm getting out.
when I get out.
He's being held until what?
We don't have a current out date from Your Honor. He is set for a preliminary examination on August 23rd. We think there may be a plea at that time, but I don't know when sentencing will be.
I thought we were asking for time because I've done some days.
I'm gonna set a first show cause in 60 days. October 21st. October 21st at 9:15, okay, sir?
Yes, ma'am.
Thank you. Unless you have questions for me, you're all set.
No, ma'am, I'm good.
You're free. Thank you. You're free to go. On the record in the matter of the people of the city of Lansing versus Jorge Zuniga Jr., file number 24-01453. council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Zuniga, listening to my right.
Today was the date that was scheduled for pre-trial. We adjourned this matter back in June so that he can get an assessment before an offer can be made to him. How we proceed?
Thank you, Your Honor. It's my understanding that the assessment was completed. We do not yet have a report. So I'll defer to Ms. Sutter on how long she's requesting.
Thank you, Your Honor. Yes, Mr. Zuniga did complete an assessment with Catholic Charities of Michigan. We would be requesting 2 weeks to allow that report to get sent from me to myself so I can share with Ms. Hagan.
August 26th. August 26th at 9:30. You have any questions for the court today, sir?
No, ma'am.
Any additional matters for the record, counsel?
Not from the city, thank you.
Nothing from the defense. Thank you.
You're all set. There was, they were gonna put Mr. Yang on?
He is in custody, Your Honor. I haven't had the opportunity to speak with him yet.
Yeah, they logged in from post 3, but no one's there. On the record in the matter of the people of the city of Lansing versus Samuel Mandy, file number 24-004. Council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Mr. Mandy, who is standing to my right.
Okay, Mr. Mandy, today's the date that was scheduled for sentencing. I do have a pre-sentence report and recommendation. The report was prepared on August 7th, 2024. Council, did you get a copy?
I did, Your Honor. I received a copy on Friday.
And did you have an opportunity to review that with your client?
I did, Your Honor.
Any changes, corrections, or updates that need to be made?
There is just one update, Your Honor, to the employment section. I believe the PSI indicated he was working at Profile Metalworking. They conducted a series of layoffs. He has now found employment at Yakazi Distribution, making the same rate of pay, $16 an hour.
Spell that.
YAKAZI Distribution. And I believe there's just one thing to add. I don't think it was in the pre-sentence report. He is also a full-time student at Lansing Community College studying cybersecurity.
Any additional updates?
I do not believe so, Your Honor.
Thought you could make allocution.
Thank you, Your Honor. I did have the opportunity to speak with Mr. Lee, the prior attorney in this case, as well as Mr. Mandy, regarding Mr. Mandy's progress throughout this case, as well as his demeanor and his attitude moving forward. And he appears to both Mr. Lee and myself be a person who is making best efforts to grow as a person, to do what needs to be done, if he hears that he moves forward as the best possible example to his community and primarily for him, his children. As I previously told the court, he is a full-time student as well as employed full-time. So these are things that are priorities for him. He's also very eager to make what the court orders here a priority so that he can continue growing and, again, setting an example for his children. Given that, Your Honor, I think this is a fair and reasonable recommendation from the probation department here, namely for the 6 months of probation with the Zoom reporting, as well as the submitting to random PBTs and the attending rehabilitative services. These are in the victim impact panel. These are all things that he's willing and able to complete with the probation department. The only sort of minor request I'd make here, Your Honor, is they've indicated that they're making a recommendation of 3 times per week AA meetings. While he's very, very willing to attend AA, Your Honor, 3 times a week is a lot for a person who is a full-time student and full-time employed. I would ask the court to consider a slightly less frequent schedule of AA attendance for him so he can prioritize all of these goals with the court. Thank you.
The 3 times a week is not something that came from probation. That came from his actual substance abuse assessment. They said at least 3 times a week is the recommendation. It's due to the criteria and the symptoms that they believe are consistent with a mild alcohol use disorder. Does your client want to make a statement today?
Not this time.
Are you currently in any rehabilitative services? Are you still drinking? I reviewed the pre-sentence report and recommendation, and I reviewed the prior criminal history, which is nothing else other than this. I believe that the recommendation is appropriate. The report indicates that you reported that your last alcoholic beverage was in April of this year.
When I got the, downstairs with the magistrate. So
Oh, okay, when you were around. Term of probation seems appropriate. I will adopt the recommendation. You'll be sentenced to 6 months probation. While on probation, you'll report via Zoom. You're not to have any alcohol or marijuana or other controlled substance while on probation unless you have a valid prescription. You will be required to submit to random preliminary breath testing and your analysis testing, and you're responsible for the cost of that, okay? Okay, no. You're not to be in any bars or nightclubs while on probation. I am going to require that you attend the victim impact panel within 90 days and provide verification of that, okay? I'm also going to order that you attend Alcoholics Anonymous. I won't order you to do 3 times a week because you're a father of 4. You work full time and you're going to school. So I would agree that that could be a lot. The recommendation from the assessor was for you to do, or suggestion, I should say, was for you to complete at least 3 times per week for a period of 3 months. I'm going to require you to do 1 time a week for the duration of your probation. Okay. You'll maintain your employment while on probation and provide verification of that. Do you have any questions so far?
just one question. Classes are going to 1 p.m., 6 p.m. No, it's not, so. To that schedule.
Do you need different employment?
It could be different. And I'm something I need to figure out.
Okay, you'll be in contact with your probation officer as your schedule shifts, but you are required to maintain employment
Okay.
while you're on probation. So if you're switching jobs, that's fine. You just need to provide verification once you do that, okay?
Yes, yes,
Okay. And fines and costs. There's a $30, I'm sorry, a $75 crime victim rights fee that will be assessed plus a $50 state minimum cost that will be assessed. $30 oversight fee for each month of probation is assessed. You're doing 6 months, so that's $180. There's $283.66 owed to the Lansing Police Department for responding to this drunk driving incident. So that will also be ordered. It's a total of $588.66, but you'll be able to make monthly payments on that. So that's about $100. Okay. Do you have any questions so far? Okay, lastly, there's an advice of rights as to probation. It states here that you've been placed on a term of probation for the 54A District Court, and the terms have been individually tailored and are specific to address your individual needs. You have the right to request early discharge from probation once you complete half the original term ordered by the court, so long as the following conditions are met. You must have completed all of my requirements for programming with no violations within the 90 days preceding your request, okay?
Yes, sir.
If you make a request on your own, because your probation officer could make the request, but if you make the request, it's your responsibility and you're required to submit or file your request with the court, but you must file a copy of your request on the prosecuting attorney's office, which is the city attorney, okay? Okay, they have 14 days from the time that you file it to file any objections in writing to your request for early discharge, okay? If I set it for a hearing, and to date, I've never set one for hearing, but if I do, you have the right to hire an attorney to represent you at that hearing. You do not have the right to a court-appointed counsel for a hearing for early discharge from probation, okay?
Yes, sir.
So again, you have been ordered to 6-month probation. Once you've gotten to the 90-day mark, if you've not violated my probation, and you've completed your programming that up to that point, which is limited. I told you to do victim impact panel within 90 days. And then if you've been consistent with your weekly AA meetings for those 90-day periods, then you can make a request, or your probation officer can make the request on your behalf. The form to do that is on the court website. It's called the MC 512 form, or you can get a copy of it from your probation officer, okay? Do you have any questions about that? Any additional matters for today's record?
Nothing from the city, thank you.
Nothing from the top. Thank you.
Okay, we're gonna send you downstairs to check in with probation, and then you'll be all set.
Thank you.
You're welcome. The record in the matter of the people of the city of Lansing versus Aisha Smith, file number 24-00666. Council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Warren's attorney on behalf of the city of Lansing.
Okay, Ms. Smith does not have an attorney, is that correct?
Correct, Your Honor.
Okay, she pled guilty previously, and it was a delayed sentence. Oh, have with the terms of the,
Your Honor, based on the notes in the file, it was a delayed sentence for a period of 3 months. And if during that 3-month period, there were no additional issues with loud animals or, the dogs in general, then the city would dismiss. I've reviewed the file and verified that there are no additional issues. As such, at this point, the city would move to dismiss.
motion to dismiss is granted. You're all set. You're welcome. Yes. And then Ariana LeDuke is here. I don't know if you need to meet with her.
I do not, Your Honor. Thank you.
Okay. Is Darrell Dispute present? No, Darrell Dispute. Well, bench warrant. Failure to pay. Christopher Dobbs. Miguel Martinez. Marcel Patterson. Antonio Urales. Wendell Aldridge in custody. Just put him on for today.
They haven't yet. They are, he's on the journey.
No, it's not. We'll just see him on Friday. Let's do that then. Let's do that then. Mr. Neal, are you ready with your client?
Yes, we are, yeah.
Okay, on the record in the matter of the people of the city of Lansing versus Jeffrey Pway, file number 17-01373. Council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence here on behalf of the city of Lansing.
Morning, Your Honor. Rico Neal, attorney on behalf of Mr. Pway, who was present at council table standing to my right.
Okay, today's the date set for pre-trials for driving while license is suspended. 2017. How are we proceeding?
I have offered to amend the DWLS to impeding traffic.
Recognize your statement. I've advised my client of the offer and at this time he intends to accept the offer.
And the fine is $135 is obtained today. Get you over to the criminal traffic window, you'll be all set.
Thank you.
Thank you. Same to you. One of this one's for him. Yes, he's gonna pay today. Yeah. Who's on the LGELM? You ready on Mr. Yang?
I am, Your Honor.
Who's in the jail post 3?
Anthony Shear, Your Honor.
Okay, on the record in the matter of the people of the city of Lansing versus John Yang, file number 24-00495, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence here on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter appearing today on behalf of Mr. Yang, who's joining us via telecom.
Okay, Mr. Yang, today's the date that we reset this furnishing false information. It looks like we were trying to adjourn for a global resolution. Ms. Sutter, you know, the other felony matters was resolved.
It is not yet fully resolved. It is still proceeding forward. However, we do have a resolution of the city filed.
Your Honor, I have offered to the breach of the peace civil infraction.
It's in time to accept responsibility, and I will do so on his behalf.
I'm sorry.
Is Mr. to accept responsibility to that offer, and I will do so on his behalf.
Mr. Yang, that's what you want to do? You're gonna pay a fine?
I'm cool with that.
When are you gonna pay the fine? The fine is $135.
Okay. You said, when am I gonna be able to pay?
Correct.
Soon as I get up out of here.
Well, I need a date.
They came at me with, they're supposed to be sending me up north to Bear River, so could be any time between here and, by like October, I'm saying. I'll be out before like probably mid-September.
Okay, I'll put that you'll make a payment by October 31st. If you don't, then it'll fix more issues, okay?
All right.
Any additional matters for the record?
Not from the city, thank you.
Nothing further, thank you.
You're all set, sir. Ready
All
on
right,
this
thank
too?
Yes, Your Honor.
Okay, on the record of the matters of the people of the city of Lansing versus Ariana LeDuke, file numbers 2402876, 442 and 441. Council appearance, please.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, here on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of Ms. Duke, who's joining us via Zoom.
Okay, I have two files here today set for pre-trial. Explanation hearing. One is a pre-trial, one's an explanation hearing. Failure to display an operator's license, and then operating while reading or typing. How are we proceeding today?
Thank you, Your Honor. I believe that Ms. Sutter is requesting an adjournment. I will defer to her for further.
That's correct, Your Honor. There is always a kind of quasi offer here from the city in reaching compliance with a license before an offer is being made. There is a hold on Ms. Duke's license and it's unpaid fines here in the 54A District Court. She is working on paying those off, but they are quite voluminous. We would be requesting an adjournment of, if the court's willing, 45 days to allow her to make as much progress on those payments as she possibly can.
What is voluminous? And how much does she owe?
$2,700, Your Honor.
She's not paying that in 45 days.
I believe the city likes to see at least some effort and progress being made on those before considering any offer here, even if she's not able to make all of them.
Is the city intending to make an offer if she makes some level of progress?
Yeah, I mean, the city is always willing to take progress into consideration, making an offer. I can't say specifically what that offer will be at this point because I don't know the level of progress. But I do see it forward here in terms of making an offer with some type of progress.
How in the world does she have
It's spread out over.
fines
a number
that
of
high
months.
and it's not in show costs? Has she been making payments on that?
I'm supposed to start my payments in August this month for $25. So I haven't paid anything yet, but if I need to make a payment, I can for sure.
Give us just a second, Ms. Duke.
First payment of $25 was due on July 1st.
I could have sworn he pushed it out. I thought he pushed it out to August. I just had my baby and I just started working again. And I let him know I wasn't going to be able to make anything for the July month. And he told me he pushed it out to the 21st of August, I thought.
The notes in the system say that you were supposed to make a payment July 1st.
Okay, I can come make that payment as soon as possible. Today, possibly. So I can pay July and August then for today.
That's all. Did they combine all those in the same thing?
That's like the thing I'll have to see.
Yeah. Okay, no, it does say, go back. No, that was from last year.
Yeah.
She was supposed to start last year in August. Okay, yeah, it says July 1st, you were supposed to start making a payment. Cause I was trying to understand how you could owe over $2,000 and there's not a show cause if you're not paying.
It's from probation fees. I know they took a lot of my probation fees and they took them down to fines and costs. So that's why the license is suspended, but it's a lot of fees and I have kids, I was homeless, my house burnt up, so.
You got a few things in here, ma'am.
Yeah, I know,
It's
I'm aware.
Not just probation.
Yeah, I know.
Give me 60 days, please.
To pay all of it, to pay 2,700?
No, I'm giving you a date. Your attorney requested 45 days to reset this matter, to give you time to make payments on your
Okay.
matter to show some progress. If I set this out 45 days, you probably would only have paid $25 if your payment plan is $25. So I don't know how that would suffice. So I asked for a date 60 days out. Give you time to make a payment this week. You'll have to make a payment, obviously in September, and then any other payment that comes due before then. And then your attorney would be in a better position to go to the city attorney's office to see if they can give you an offer, okay?
Yes, ma'am. I also had a question. I didn't know if it was possible or how I would get those other fines, those other costs, of how I would get like those reduced.
I have no idea. Yeah, it's a lot of stuff and I don't have the files, so, and I don't even know what they are. So I don't know how you can get them reduced. You should have your attorney try to come in here another time and I can pull those files and see what's going on in there. I don't know what they're for.
They're from Judge
Okay.
Flores. I actually represent her on.
Oh, okay. It looks like they're for Judge Flores and and your attorney is representing you on some of those. So I'm inclined to believe if they could be reduced, she would have requested. I don't know. I don't know if it's restitution or what.
It's just the fines and costs assessed by the court. I don't believe.
From 2018 and 2017.
They resolved last year. Most of them.
Yeah, well, some of them. One she owes 808 on. And she was on probation when? That's a Buchanan. That's a Buchanan. The one that she has the highest amount owed on is actually Buchanan file. She would need to go to each of those judges to find out if anything can be waived. I don't know. I don't know which one of those is holding her license or if it's a combination. But you should talk to your attorney about that, okay, ma'am?
Yes, ma'am.
October 20th at what time?
October 21st.
October 21st at 9:30 will be your next court date, okay?
Yes, ma'am.
You have any other questions for the court?
No, ma'am.
Any additional matters for the record?
Not from the city, thank you.
Not from defense.
Okay, you're all set, ma'am.
Thank you.
You're welcome. Speak to Mr. Shearer.
I will brief you, Your Honor. We also do have a couple of people in the courtroom too. I don't know if they can check that or not.
That was Aisha.
Two.
We got James Hall, Andrew Kidd, and Cato, Lydia Cato. Everyone else checked in?
Are you ready on Hall?
I'm not, Your Honor.
You ready on Kidd?
Yes.
On the record of the matter of the people of the city of Lansing versus Andrew Kidd, file number 22-00046, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Kidd, who is standing to my right.
Okay, Mr. Kidd, today's dates up for pretrial. I have a trespassing and a hinder and obstruct oppose an officer. Was there an offer? Yes.
Yes, Your Honor, I have offered to dismiss the hinder opposed portion of the ticket if Mr. Kidd pleads guilty to the trespassing. It's my understanding he intends to accept that offer.
That's correct, Ms. Sutter.
It is, Your Honor.
I'm sorry, sir, can you raise your right hand? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Hand down. Okay, you're gonna plead guilty to trespassing, sir. You have to give up your right to have a trial. You have the right to the presumption of innocence and the right to have jury trial. You're innocent until proven guilty. You have the right to require the city to prove your guilt as to the both charges being brought against you by proving each element of the charge being brought against you. You can remain silent at trial and not have silence be used against you, or you can testify on your own behalf with subpoena witnesses to testify for you at trial. You can present evidence that you believe show defense to these charges, and you have the right to confront and cross-examine in court any other witnesses that the city intends to call against you. You understand all of those rights? Yes. You're willing to give up them today to plead guilty to trespass? Anybody threatening you to get you to do that? No. Any promises being made in exchange for you entering a guilty plea today? No. As to trespass, how do you plead? Yes. So because you believe you're guilty? Yes. Factual basis.
Thank you. Mr. Kidd, on or about November 28th of 2021, were you present at 401 West Greenlaw Avenue? Yes. That's otherwise known as the Veteran Hospital? Yes. And that's in the city of Lansing? Yes. Ingham County, Michigan? Yes. And at that time, were you asked by hospital staff to leave the premises? Yes. And did you remain after you were asked to leave? Yes. Thank you, and I believe that satisfies the factual basis of drug tests.
The city satisfied with the factual basis.
Court is satisfied with the factual basis. I'll accept your plea if I have been freely, voluntarily, and intelligently made. He did originally have a PR bond, but this is a 2022 case, and it looks like he failed to appear multiple times, and there was bench warrants issued. And so he would have spent some time in jail on this. I just don't know how much time that was.
I don't have a fully accurate counting either, Your Honor, given the notes in the file. I believe it's around a week, but I don't have an exact number.
Present time served, he's all set.
Thank you, Your Honor.
Let's see. Lydia Cato, you ready on her?
Yes, Your Honor.
On the record in the matter of the people of the city of Lansing versus Lydia Lorna Cato, file number 23L2760781. Council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Ms. Cato, who is standing to my right.
How are you, Ms. Cato? Today, we reset this matter for a pretrial and expired license. She requested court appointed counsel. How are we proceeding?
Thank you, Your Honor. I have offered to amend the charge to impeding traffic. It is my understanding that she is going to accept.
That's correct, Your Honor.
The fine is $135. Are you paying today?
About 2 weeks.
weeks from today is the 26th. Okay, by then?
Mhm.
Is that a yes? I don't know that you'll make payment by the 26th. If you, for whatever reason, need an extension, you need to come up to the court to get that extension, okay? Any additional matters for the record?
Not from the city.
Thank you.
You're all set.
130.
135.
Thank you.
You're welcome. Xavier Williams, please start your video. Kayla Bowers, start your video.
Okay.
Whoever's on the LGELM, this is the last request to start your video, or I'm removing you from the virtual courtroom. If you had a court date, you'll get a bench warrant.
Hi, can you see me?
I can see you.
Okay.
Okay, so you need to speak with Chair, you need to speak with Mr. Hall,
Yes, yeah.
and then, did someone else check in?
Mr. Williams.
Who else just came in the courtroom?
Hey, Mr. Hall. Mr. Hall right there.
This is Mr. District.
Desmond, I need the file back, I think I did a bench warrant for him. And then Xavier Williams, you need to speak with him,
Yes, Your Honor.
and then what about Bowers?
Yes, Your Honor.
Okay. Mr. Desmond? You're supposed to be here at 9:15, where were you?
I was out there. I didn't know I was supposed to come in here.
To check in? You owe $174.
Yes.
You were supposed to pay that. You've owed that since 2019, since 2025, almost. When are you gonna pay it?
I can pay it this week.
What day this week?
By Friday. Deadline by Friday.
You've been show cause on this multiple times, so if you don't pay it this week, I'm gonna have to issue a bench warrant.
Okay.
Okay? I'll note that you'll pay by Friday. You're all set.
All right. Thank you.
What's your name?
Hi, my apologies, Your Honor. I was having some difficulties with my phone. My name is Aisha Green. It didn't give me the option to put my name up there.
Your video is not working.
Yeah, I don't know exactly what's going on with my camera at this time. I was trying to fix it.
Yeah, I
Can
don't know
you
what's
see
going
me
on
now?
either. I cannot see you.
Okay. I don't know how to fix it. I don't. Okay, is this better? Can you see me now?
I don't see you at all. Are you ready? You on someone?
We're already on call, Your Honor, and then I was waiting for that breakout room with Williams and Powers.
Okay, we'll take care of all. And then Aisha Green is here. Her video is not working. Did you need to meet with her?
Your Honor, she was denied a public defender. You said Aisha Smith.
I'm sorry.
Sorry. I
I'm
apologize.
sorry. I was
Aisha
denied
Green.
what? I didn't hear you.
Aisha Green was tonight.
I'm sorry. Aisha Green is a public defender client.
Oh, okay.
I was mistaken her for Aisha Smith.
Got it. Okay. Did you need to speak with her though?
Yes, Your Honor.
Okay, I'll let her stay on that. She's not able to work her video. You can meet with her if she
I'll try and talk her through.
will, yeah, otherwise we'll reset her.
Okay, thank you.
On the record in the matter of the people of the city of Lansing versus James Adolph Hall, file number 21-01166, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, here on behalf of the city of Lansing.
Good morning, Your Honor. This is the public defender Lauren Sutter on behalf of Mr. Hall, who's standing to my right.
Okay, Mr. Hall, this is a free trial and a driving while license is suspended. That we adjourned multiple times and then he failed to appear. How are we proceeding?
Thank you, Your Honor. I have offered, if Mr. Hall please to the DWLS, that I would Killebrew to time served. It's my understanding he has about 5 days on this file.
He's gonna proceed. He did have a different offer in November 2023, but
Your Honor, from my notes, if I may, a previous offer was that if he was able to correct the suspensions, an offer would be extended. He has not been able to correct any of those suspensions.
the offer was allowing a suspended person in November of 2023. And said he had some child support issues. Holding up his license. Assuming he still has the child support issues, that's the issue.
He's completely cleared those up. He's waiting on a administrative hearing with the Secretary of State. That's the hold up right now.
Secretary of State, Your Honor, is still showing that child support suspension on our most recent time that.
You know, even in December 9th, because that was November where I noted the offer, December 19th, said the hold was cleared. He was waiting for some documentation. Then he came in February, Secretary of State hearing needed to be rescheduled. Because he didn't provide him with his updated address, so the hold is not clear. And if the hold was cleared, then his license would be reinstated, correct? No?
No, Your Honor, he needs a hearing in order to get his license. He's got a history of fatal crashes on his driving record.
okay.
So that is also.
So it's not just a child support issue.
That's correct.
And he has filed the paperwork for the administrative hearing. He's waiting on a date.
Okay. The offer was what?
A plea to the
Plea.
charge with a Killebrew of time served.
Counsel, you want to proceed?
He wishes to accept that offer.
That's correct, sir. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay, so you're willing to give up your right to the presumption of innocence, sir? You have the right to have a jury trial on this matter and require the city prove each element of driving while license suspended beyond a reasonable doubt. You want to give that up? You have the right to question or cross-examine any other witnesses that they intend to call. You have the right to call your own witnesses or present evidence that you believe show a defense to the charge being brought against you. You can remain silent at trial and not have silence be used against you, or you can waive your silence and testify at your trial if you like. You want to give up all of those rights? Anybody threatening you to do that?
No.
Any promises being made to you in exchange for a guilty plea? Driver while license is suspended. How do you plead? Factual basis.
Mr. Hall, on or about April 28th of 2021, were you driving a vehicle on or near South Martin Luther King Boulevard and Mary Avenue? And that's in the city of Lansing, Union County, Michigan. And at that time, were you driving a vehicle while your driver's license was suspended, revoked, or denied? Thank you, Your Honor. I believe that satisfies the factual basis.
City satisfied with the factual basis.
I'm satisfied with the factual basis. If I accept your plea, if I be freely, voluntarily, and intelligently made. I'm just trying to figure out how you would have 5 days on this.
On bench 1, 2/3 to appear to the accrued overtime.
He was late on one bench warrant. I quashed it. March 18th, I issued a bench warrant. However. Let me see what I'm doing. Looks like he was picked up. He was given a date of arraignment, right? So I don't think he was taken into custody for that. I don't think he was taken into custody for it. I don't think he was taken into custody. It looks like he showed up. He was given a date of arraignment, which was for July 22nd. He came on July 12th and they gave him a 22nd date. Where did he get credit on this?
Yeah, I'm trying to figure that out. I spoke with him regarding the time he spent in custody. We do know that he had spent time in custody and other things. I've been trying to match up dates between bonds on this one. He advised me he believed it was 5 days on this one. Again,
He didn't serve any time on this. He came on the 12th of July. There was a warrant and he was given an arraignment date, probably because he walked in and no one was able to arraign him. He didn't serve any time on this. And then he came in for his arraignment, July 22nd. Magistrate continued his bond. Here we are today. So I can't killabrew him of no time. So he's either gonna get a fine or he can withdraw his plea.
what he just said, the John will take the fine.
The fine is $200. What can you pay?
30 days pay.
Yes. Oh no, you're okay within 30 days, you're all set. And then you need to meet with the people. Mr. Shearer, you need to stand and move because that's a motion censored light. Thank you.
Here you go, Your Honor. I apologize.
No problem. I'm gonna add you to room 1 to meet with your their attorney up, that is. Let me see. No problem.
Oh, excuse me. I don't know why my camera isn't working. Doesn't make any sense. It worked last time.
I'm on an important meeting. I'll come out when I'm done.
Mr. Williams, can you join the breakout room? Ms. Bowers, can you join the breakout room?
Yeah, I'm still waiting.
This is still long. I'm not breathing out.
On the record, in the matters of the people of the city of Lansing versus Anthony Robert Shearer, file numbers 21-00201, 204, and 631. Council appearances.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Letter on behalf of Mr. Shearer, who's joining us via Polycom.
Okay, Mr. Shearer, I have 3 files. One is a failure to stop after a property damage accident. There's a bond violation in here. And no insurance. And then I have a operating while intoxicated, and all of these files tell me to see file number 21-02412 for a bond violation, which was in each of these files. As to file number 21-00631, warrant was issued after he absconded from treatment. How will we proceed on this?
Thank you, Your Honor. I will defer to Ms. Sutter on this one.
Thank you, Your Honor. I unfortunately was not aware of any bond violations issued here. As for the pre-trials that were scheduled for today, Mr. Shearer does have a case in front of the 55th District Court where specialty court is being sought for him. We would be seeking an adjournment there to allow us all to see if he's clinically and legally eligible for that specialty court.
What is going on in 21-024? 21-02412. That was the one he was on. Well, he said for treatment the day after. Yeah, but he was an eye sensitive treatment.
Your Honor, is that the probation case?
Right.
That was, I think that's been rescheduled for the 27th.
Yes, because he was supposed to be here on Friday, and the jail said that because of his behavior, he was sent back to the county.
Correct.
Wasn't my behavior. They couldn't take my jeans off. I used the bathroom really bad. I'm sorry. It was not my behavior.
I don't know anything about what happened, sir. All I know is that we sent someone to pick you up and you weren't down there. So you don't need to explain to me what happened because it's not an issue for the court. Okay? We just reset the matter. Yeah, we reset the matter to August 27th on that matter. That's the one that was probation. Okay. So you want this reset so that he can be screened for variety court?
I believe it's drug court that's specifically being looked into, but Amanda Tringle of my office is looking into a specialty court in the 55th case.
Okay, it was, I thought, well, my understanding is that the 55th wasn't taking any more of our files for that court.
The sobriety court, which Judge Allen is not, I believe Mr. was looking into the drug court, which is out of, I think, 54B. It's the current file is with the 55th District Court. I don't think the specialty court is there.
Got it. Okay, let's see here. And so how much time do you need?
I mean, I know Mr. Shearer is concerned about delaying this for too long. Realistically, I think the screening for clinical and legal eligibility may take a little bit of time, 30 days. I know, however, he's concerned about adjourning that long.
I'm not concerned about what Mr. Shearer is concerned about because he delayed this. He delayed all his cases by not coming to court. So we'll reset this 30 days.
September 16th, 9:30.
September 16th at 9:30.
Your Honor.
Excuse me? It's breaking up a little bit. I didn't hear what you said.
You.
Okay,
I think it's a thank you.
okay. Any additional matters for the record?
Not from the city, thank you.
You're all set.
Yeah.
Okay, on the record in the matter of the people of the city of Lansing versus Sheila Bowers, file number 24L2863831, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, here on behalf of the city.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter appearing today on behalf of Ms. Bowers, who's joining us via Zoom.
Okay, Ms. Bowers, today was the date set for a pre-trial and expired license. How are we proceeding on this?
Thank you, Your Honor. I believe if there is another request for an adjournment in this file, I will defer to Ms. Sutter.
That's correct, Your Honor. She's been in contact with the Secretary of State. They have advised her of how to move forward getting her permit and told her that it'll take at least 30 days. I would request an adjournment of 45 days to allow her to complete anything needed with the Secretary of State and get back to us.
September 30th.
September 30th at 9:30. You have any questions today, ma'am?
No.
Any additional matters for the record, council? You're all set, ma'am.
Okay, thank you.
You're welcome. On the record in the matter of the people of the city of Lansing versus Xavier Lamar Williams, file number 24L2874522 and 21. Council appearance, please.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, here on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Williams, who is joining us via Zoom.
Today's the date and time that's set for two trials. One's for failure to display operator's license and then actually explanation hearing for speeding 1 to 5 over. How are we proceeding on this?
Your Honor, I have made an offer. The city will be dismissing the failure to display a valid license and granting the speeding 1 through 5 to impeding traffic. It's my understanding Ms. Williams intends to accept that.
That's correct, Your Honor.
It's $135. When are you gonna pay, sir?
I'm sorry, could you repeat that, please?
Your fine is $135. Are you paying that today?
If it's possible, could I have some time?
How much time?
I just need like a week. I have some finances that I haven't cleared yet because it was just a weekend. That's all. Some bills to pay.
Okay, you'll pay no later than the 30th.
Yes, ma'am. That should suffice.
Okay, any additional matters for the record today?
Not for the city, thank you.
Nothing further, thank you.
Can I ask where I pay that though, please? Where do I pay
You can
that?
go on, you can go on the court website and you would use your case number, the one that ends in 521, because that's the one that was amended. Or you can come up to City Hall, you'll go to the 6th floor at the criminal traffic window and you'll pay there, okay?
Yes, ma'am. Thank you very much. And thank you
You're
guys.
welcome. Have a good one.
Thank you as well.
They didn't put Bobby or is McConaughey downstairs? Oh, okay.
Did I hear that he was downstairs?
What else do we have here?
We also,
I see Ms. Palacios here.
yes, she is.
On the record in the matter of the people of the city of Lansing versus Mariah Palacio, file number 23027888762. Council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Moore is here on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Palacio, who's standing to my right.
Okay. Okay, Ms. Palacio, we reset this matter so that you could have your appointment, I believe, with Secretary of State. Is that correct? The updates.
Yes, Your Honor, she did attend that meeting. She was given a letter of denial there. We have a resolution.
I have offered to amend the fail to display ops to allowing an unlicensed person to drive. It's my understanding that Ms. Palacio intends to accept.
That's right.
Correct, you want to accept that offer? Correct. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you can put your hand down. Okay, so you have the right in this matter to proceed to jury trial. You have the right to be represented by your attorney at your trial. You have the right to the presumption of innocence. You're innocent until proven guilty, and you have the right to require the city prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence for you. You can chew, you can waive your silence and testify on your own behalf. You can subpoena witnesses to come and testify for you or present evidence that you believe show in defense to the charge being brought against you. And you also have the right to see, hear, or question in court any other witnesses the city intends to call. You want to give up all of those rights? Anybody threatening you to do that?
No.
Any promises being made in exchange for you giving up those rights? As to the amended charge of allowing an unlicensed driver to operate, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes.
Actual basis, counsel.
Thank you. Ms. Palacio, on or about May 4th of 2023, were you driving a vehicle on or near South Martin Luther King Boulevard in Victor?
Yes.
And is that in the city of Lansing, Union County, Michigan? And at that time, did you allow a person with a suspended or no license to drive a vehicle? And that person was yourself?
Correct.
Thank you, Your Honor. I believe that satisfies the factual basis.
The court is satisfied. Did you have any additional?
No, Your Honor.
We'll accept your plea and find your plea made freely, voluntarily and intelligently. I see here July 9th, she posted a bond of $200 cash. Apply the bond, the file's closed.
Thank you, Your Honor.
You're welcome.
I was trying to walk Miss Green through getting her video on. I, at some point, advised her to log off completely and log back in. Did she reappear?
Yes, but her video's still not working. She's logged off a couple of times. It's not working, so I'm going to reset her matter. She can appear in person.
Take your.
August 19th at 10:30. August 19th at 10:30 in person, okay, Ms. Green?
Yes, Your Honor.
Any additional matters for the record, counsel?
Nothing to say, thank you.
No, Your Honor, thank you.
Thank you. You're all set for today, Ms. Green.
Okay, you said August 19th and the time?
10:30.
Okay, thank you.
You're welcome. And then who else do you have?
Mendoza?
The one that needed the interpreter?
Both. We have two that needs interpreter.
Yeah, I think the interpreter called and it's gonna be late. Lerma is on Zoom. And we can bring McConaughey up. That's Mr. Lum. It's on the 11 o'clock. We can bring McConaughey up. And we're ready on Lerma. Lydia Lerma, if you can start your video. Not seen Bobby Harris? No?
No, Your Honor.
You gotta have these files, Bobby. Should benchmark. On the record, actually, Lerma's logging back in. Okay. Olivia Lerma, can you hear us? You're muted.
If you tap on your screen and look in the bottom left corner, you'll see a microphone. If you tap that, it should unmute you.
Okay, got it. Sorry.
Oh, no problem. On the record in the matter of the people of the city of Lansing versus Olivia Guadalupe Lerma, file number 24-01779, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Lerma, who's joining us via Zoom.
Okay, Ms. Lerma, today was the dates of preparing on pre-trial, that is for no insurance. How are we proceeding, counsel?
Your Honor, at this point, the city would move to dismiss.
No objection, Your Honor.
Motion to dismiss is granted. You're all set, Ms. Lerma.
Thank you.
Okay, four body hair files, not. Palacio, we needed an interpreter for Mendoza.
And Lerma.
Alonzo.
No,
Or
she
I'm
said
so
Lerma.
sorry, Alonzo.
Alonzo,
I got
okay,
the wrong name.
got it. And is Nanette Lowry here?
I am not seeing Your Honor, although I was gonna go check the hall briefly.
Okay, thank you. They never have Edwards on?
That was who was supposed to be in the other.
One's there.
There was no one in the hall, Your Honor. Well, not for this court.
My records was that Nanette was at Bear River. You know, and then it's still at Bear River?
Yes, the last indication from Mr. Lee, when I checked with him that she was at Bear River, that last update came from the end of July.
No indication as to how long.
No, Your Honor, I did personally speak to staff at Bear River. I believe we had a court date on July 22nd to advise them of the new date today at 10:30. That's the last communication I was able to have with them.
I said it. August 26th at 10. August 26th at 10. Let's find out why they didn't put Edwards on. I don't know what happened with that. She's bringing up McConaughey. And then I don't know what's going on with the interpreter. But it's 11 o'clock. And tell them to be in person. I don't understand why they're talking to the thing that's The record in the matter, the people of the city of Lansing versus Robbie McConaughey. File number is 20-01517. Council Clerk.
Thank you, Your Honor. Deputy City Attorney Aisha Lawrence, appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. McConaughey, who's standing to my right.
Okay, today was set for a trial for operating while intoxicated and a possession of drug paraphernalia. How are we proceeding on this?
Your Honor, I believe we have a resolution in this file. I have offered to amend the operating while intoxicated charge to operating while impaired. And the city has offered to drop the drug paraphernalia charge.
Second.
Thank you. Yes, Your Honor. That is the offer that was conveyed to me that I have walked through with Mr. McConaughey, and he does wish to accept that today.
That's correct, sir.
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
You can put your hand down. Okay, in order for you to plead guilty to the amended count of impaired driving, we'd have to understand certain rights and then be willing to give those rights up versus your right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, Your Honor.
You have the right to require the prosecution prove your guilt by proceeding to a jury trial and proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to be silent at that trial and not have that silence be used against you, or you can waive your silence and testify at your trial if you'd like. You have the right to subpoena witnesses to testify on your behalf or present evidence at trial that you think show a defense to these charges. And you have the right to waive your silence and testify on your own behalf. You want to give up all of those rights?
Yes, Your Honor.
Anybody threatening you to do that?
No, Your Honor.
Any promises being made in exchange for you entering a guilty plea on this?
No, Your Honor.
Are you currently on probation or on parole?
No.
You're being held in Eaton County for what?
For possession.
You're serving a sentence or you have a pending matter?
No, I'm serving a sentence. I get out on January 14th with no probation on the.
You previously had probation, is that correct?
Yes, I did.
Okay. Is that in Eaton County?
Yes.
Is that what you're serving on? So you were,
Yeah, they revoked it.
they revoked your probation status,
Yes.
okay. You understand that a guilty plea could result in a conviction that you may need to put on a future job application.
Yes, Your Honor.
It also could have impact on travel and immigration status you may seek. So you may want to go visit Canada and this charge could prevent you from doing that. You understand that?
Yes, Your Honor.
As to the amended count of operating while impaired, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes, Your Honor.
Have a factual basis.
Thank you. Mr. McConaughey, on or about March 7th of 2020, were you operating a vehicle on or near North High Street and McKinley Street?
Yes, Your Honor.
Is that in the city of Lansing?
Yes.
Union County, Michigan?
Yes.
And at that time, had you taken some kind of a substance prior to driving?
Yes.
And do you believe your driving was impaired by taking that substance?
Yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the city?
No, Your
Court is satisfied with the factual basis. I'll accept your plea if I'm to be freely, voluntarily, and intelligently made. My record reflects that he is in custody in Eaton County until January 2025.
That's January 14th, 2025, yes.
Your sentence will be 93 days in county jail, which can run concurrent to the sentence you're serving at Eaton County. You do owe $421.71 to the Lansing Police Department for responding to this incident. That will be ordered. $75 crime victim rights fee plus a $50 state minimum cost. You can set this for a show cause in January so that you can begin making payments, okay?
Yes, Your Honor. Thank you.
What's your address?
It is 199 East Thorn Ridge Lane, Mount Morris, Michigan. 485 or 48458. Genesee.
Okay, that's where we'll send your notice for show cause. We'll have it set after January 14th. Any additional matters for today's record?
No, Your Honor.
No, Your Honor.
You're all set. I don't know why you put, the other guy on, we'll look into that. And you're ready on the interpreter matter, or you still need to talk to them?
Your Honor, I'm ready on Mr. Alonzo and Mr. Mendoza.
Okay, on the record in the matter of the people of the city of Lansing versus,
I believe these are both required.
let's see here, unit Alonso, file number 24L2859791, council appearance.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city of Lansing.
Assistant Public Defender Lawrence Letter on behalf of Mr. Alonzo, who's saying, my right.
Your name,
Susana Villarreal,
can you spell that?
SUSANA VILLARREAL.
Raise your right hand. Do you solemnly swear or affirm that you're interpreting the matter before the court completely and accurately and not divulge confidential communications? I'll help you God.
I do.
Today's the date set for a pre-trial. It's for failure to display ops, which is an operator's license. How are we proceeding?
Your Honor, we would be requesting an adjournment so that Mr. Alonso has the opportunity to correct his driver's license. Obtain.
How much time does your client need?
Your Honor, he's scheduled to take his driving test on the 15th. I request 30 days to allow him to get through that.
Said on which day is he scheduled?
He's scheduled to take the road test on August 15th, and I want to make sure he has time afterwards to get the paperwork.
September 16th and 9:30.
September 16th at 9:30. Alonso, do you have questions for the court today?
No, Your Honor.
Any additional matters for the record?
No, Your Honor.
No, Your Honor, thank you.
You're all set.
Your Honor, should he wait for a printout or will it just be mailed?
I will give him a printout today. We'll print it out and then you can grab it since Juana's not here.
Yes, thank you.
Okay, on the record in the matter of the people of the city of Lansing versus Jesus Mendoza Posadas, file number 24-01672, appearance please.
Thank you, Your Honor. Deputy City Attorney Lisa Hagan Lawrence, appearing on behalf of the city of Lansing.
Good morning, Your Honor. Assistant Public Defender Lawrence Letter on behalf of Mr. Mendoza, who's saying to my right.
Today's the date set for pre-trial. Jury to stop after property damage accident. How are we proceeding?
Your Honor, the city would move to dismiss.
No objection.
Motion dismissed is granted. You're all set. You're welcome.
Yeah.
Lauren, did you call the jail and find out what happened with Edwards?
Yes.
I think is our last city case today. On the record in the matter of Brooke Ashley Church versus Bruce Hicks. Potential 23-01873 GC. Also, can I have your appearance?
Good morning, Your Honor. Brian Loma on behalf of the defendant.
Okay, and ma'am, state your name for the record.
Brooke Ashley Church.
Okay, today's the date that was scheduled to continue a trial. And I requested certain documents to be provided today by the defense. Then you had the right to all rebuttal witnesses based on the defense's witnesses today, if that's what you intended to do. Do you have the documentation I requested?
Your Honor, I believe at the end of the last hearing, you said that your judicial assistant had looked it up online.
I told you that you didn't have to provide any documents. And that my recollection was you were supposed to provide me documents that indicated who was the owner of Coast to Coast and Unlimited Potential, because you're a witness, the named defendant one under oath didn't seem to be able to tell the court who owned these companies. Are you calling rebuttal witnesses today?
Yes.
Okay, who do you intend to call?
Bruce Hicks.
You're calling him as a rebuttal witness?
Oh, no.
Or you just want to question him?
Yes, question next to him.
Okay, so he can retake the stand then.
Is that now, Your Honor?
Yes. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Do it again with your hand
Sorry.
raised. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
You can have a seat. Who was both?
Mr. Edwards and Aldrich.
Oh, yeah, we knew Aldrich was released because he didn't show up on Friday, but
Yeah.
Edwards was released as well.
Yes.
We'll do a bench warrant.
Okay.
Okay, you can proceed to question the witness.
Okay, so the last time that we were here, you said that you did not know about me having heat since 2020, correct?
No.
You did not know about, your question was the last time he didn't know about you having
Yes,
heat
you
or
said
not having heat?
Not having heat since 2020. You said that you haven't noticed anything about me having heat since 2020.
That's incorrect. We provided receipts to show that we made repairs since 2020.
When was the last time that I told you that I didn't have heat that you recall?
I guess you need to tell me the last time you.
No, you can't answer her question with a question. You have to answer her question.
I don't know specifically.
I wrote down that you said that you did not know that I did not have heat since 2020.
We provided receipts of multiple repairs after 2020. So we have had conversations about it, and the company that sent out multiple receipts were admitted into evidence that shows HVAC repairs happen.
Okay. I have text messages that prove that I let you know every single time, every winter that I've lived there since last winter that I did not have heat because he stated.
You're asking him questions, so not giving testimony.
Last time.
So your question is, so you're saying that you have text messages. So I guess you would want to ask him, are you disputing that she has text messages where she communicated with you each winter about a heat issue?
I'm sorry, can you?
Are you disputing that she has text message communications between you and her where she notified you of an issue regarding the heat every year?
I guess the answer to my question is whenever repair request was made for HVAC, it was complied. There are receipts that are on file that date after 2020. There's receipts in 24, there's receipts in 23, there's receipts, and these are all in the exhibits that were submitted to the court.
What exhibit number is that, Mr. Was that H? I just have drain commission stuff for that. I have defendant's exhibit E that is a heating and cooling. That's the only one I have for heating. Should the court have another one, Mr. Long?
That was the only one from last time. Your Honor.
Okay. Okay, so again, her question, are you disputing that every year she reported an issue with the heat?
I'm not ordering an issue with the heat, but
Your statement is that it was repaired.
that is correct.
And you believe that there should be receipts from every year being repaired, or is your testimony that that one receipt that reflects the repair in 2020?
You said 2024, right?
Sorry?
Did you say 2024?
I don't know. I didn't ask him about 2024, but are you saying that the one, I have one heating and cooling receipt from, that was admitted from, looks like the date was July 2022. Are you saying that that would reflect the only effort that you've taken to address the heat, or should there be other records?
There should be other records. Can I go to Brian and to get the paperwork?
He's got a bar license. If he has the paperwork, he should be able to pull it while you answer the questions.
Okay. I don't know off the top of my head, Your Honor, so I'll
Okay,
wait.
but you believe you provided him other records for heating, for repairing the heat. I'll let him look for that while you answer her next questions.
Okay, so you guys did provide documents of the drain, the furnace, the professional companies coming out. Why was there no professional company coming out to fix the porch? No construction company or nothing recorded there?
Well, you just referenced we were providing receipts. Are you talking about just the one receipt for HVAC, or are you talking?
The one receipt or any, you provided all the companies for the repairs throughout the whole house, but the steps. Nobody, you didn't provide any construction paperwork or any receipts or anything for that. Is that correct?
No, we provided pictures.
No, it's correct. No, it's not correct.
Ask the question again, please.
You provided professional companies that came and fixed the water heaters, the drain, the furnace, the duct, all those. But why did you not provide a professional company that came and fixed the porch?
I guess one isn't needed, right? Unless you're pulling a building permit, you don't need to have a licensed professional. However, for drains, HVAC, you have to be licensed to work on those. I guess those appliances.
So was it your friend that came and fixed the porch?
No.
You have no personal relationship with the person that came and fixed the porch for me?
When you say a person, do I know them? Yes. Are they
Like a
friend?
close friendship?
Negative. This is a person who's compensated for doing work. This is not a
Is
friend.
he a professional?
Professional what?
Is he a professional anything?
That's way broad. That's too broad.
Is he a professional contractor, construction?
Is he
a professional to fix my porch for me? So
The
that I
person
wouldn't
is
fall?
competent, and you do not need to have a builder's license to make a repair.
Move on to the next question.
Okay. Were you aware that he was smoking marijuana during him fixing the porch?
Marijuana is a legal drug,
Well, she didn't ask you that.
right?
Were you aware that he was smoking
No.
marijuana?
And this is still hearsay. He's not here to defend himself, so I don't know. if-
That's not hearsay. She's saying,
I don't
and
know
she's
if-
asking you, were you aware?
I do not
It's
know.
just yes or no.
Okay. Have you fixed everything that the city of Lansing has asked you to fix in my rental?
I think the only thing that is outstanding is the permit in which they said, I spoke with them last, the person who did the inspection is retired, so they're just gonna pass.
So the breaker.
Let him answer.
Last I knew, all the repairs were made.
So the breaker being labeled is repaired at my house.
Last I knew, it was repaired. I have not physically been there.
I have, the breaker is not.
That you're not giving
Okay.
your argument or your testimony.
Okay.
He's giving answers. And so even if you don't like his answers, you can, I don't know if you have a pen, note that down, and then
Okay.
you'll give an opportunity to give rebuttal testimony if that's what you want, and
Okay.
provide evidence in support of that. But you don't get to tell him what his testimony is going to be, okay?
Is the front deck fixed and replaced like the city of Lansing asked you to do by 3/8/2023?
To the best of my knowledge, yes.
I have nothing further.
Thank you. Mr. Lum, did you find the additional paperwork that he referenced?
I do have a, what's your honor here?
Show her. Okay, can you tell me what this is?
This is an HVAC repair. It looks like there was a service call, clean flame sensor and pressure switch part replaced with original equipment gas valve. So this was for the furnace.
This is for the furnace.
This is for the furnace.
Okay, so do you believe that this was done in response to maybe communication you received from her about the heat? Okay, and that was what date?
It's like this one was dated February 19th of 24.
Okay. Any other questions about that issue, ma'am?
It's not really a question, but nobody's came to my house in the past year. Nobody,
Okay,
no
so that's not a
companies.
question. So he can be excused from the stand then.
Okay.
Thank you, sir. You can return to where your attorney is. Okay. And you want to give some counter argument to some of the things that he stated, is what you're saying?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, you can proceed.
Can I start with this? Nobody has been to my house since I filed for this civil suit back in 2023. No company, not Bruce, nobody has been to my house at all. So I don't know where this is from, but nobody has been in the past year to my house.
Okay.
When it comes to the deck, he fixed the steps, but the rental inspection stated the front deck was damaged and deteriorated and the deck boards need to be repaired. That has never happened at all. There was a repair to the steps only because I fell through them when I was pregnant. That's why the repair happened on the steps. But the rental inspection, Chief Meredith stated that the front deck and deck boards need to be replaced, and that has not happened at all.
Any other argument? I'm sorry, testimony at this point that you're.
I do recall, I know that everything's recorded, but I do recall him stating that he has had no recollection of me not having heat since 2020, hence why I wrote it in my notes. And I have been begging him for over 2 years about the heat being fixed, trying to get it fixed. Last year, I had to have heaters, and he had to bring heaters, clothes, and everything for my newborn. I mean, I wouldn't be here today if those would have been fixed. So.
Okay, and when you said you communicated that to Mr. Hicks?
Yes.
How?
Text messages, pictures of my thermostat being at 63 when it's set at 74. Text messages first in 2023, and then this is in February of 2024 of the thermostat being 63:59 when I woke up in the morning, my newborn.
Did you show Mr. Lumley's?
The service panel also does not still lacks the proper labeling at the breakers. Like he said that they came out and fixed it, he did not.
The service paneling?
The service.
Okay, so
Yeah,
you're referencing your exhibit 2 where it said that there were certain things cited and the compliance date would have been April 7th of 2023. Section 605.1 service panel lacks proper labeling of breakers. Is that what you're talking about?
yes, correct. And to this day, they're still not labeled. I have it on my phone because I couldn't print a picture. It was too dark when I printed it. But I have this taken Saturday and there's no labels on my breakers at the house.
Okay, and so let's see. I'm talking about the photos that you just showed, Mr. Lum. Mr. Lum, are you objecting to those being an exhibit?
I don't have any objection to the specific photo, I just have one.
Yeah, these are different days. What was there? 61, there's one at 63. Oh, these are there. Yes. So this one is at 63. That was at 10:40 p.m. This is at 2.
You said no objection?
No objection.
Okay, so that would be, I think, plaintiff's exhibit 3. We can get that from her. Okay, so the first page is supposed to, it's dark. It's supposed to be February 17th, 2024 is what you're stating?
Yes, correct.
And who is, this is your phone?
Yeah, this is my thermostat. Oh yeah, that's my phone, yeah.
And you took this and you're saying that you sent this to Mr. Hicks?
Correct.
Okay, and so I think, I can't see the time, but is it about 2 o'clock?
Yeah.
And you're saying that your heat
should be at the top one is what I have it set at. And
it
then
says 74?
Yeah, and then the big number is what it would just stay at.
Okay. And then I see another message that looks like it was the same date at 10:40 p.m.
Yeah, that just stayed the same. It wasn't.
Okay.
What you could tell
It's
it
like
wasn't
a 61 degrees. Do you have responses from him?
No.
Why not? Why not? How do you just have these and I don't see the full communication?
There was no communication after I served him papers for court.
No, but you sent him these?
Yes.
In a text message?
That is, yeah, those were not in a text message. Those were the pictures of the thermostat.
Okay, so how did you notify him about this?
I notified him on the text message, but I had gotten a new phone at that time.
Okay.
So I don't have those text messages from last year of me contacting him about the heat. From
but you still have the pictures?
Yes, I have all the pictures still. The pictures stayed in my Gmail, but the text messages did not.
Okay. Any other evidence or proofs that you want the court to consider?
Other than the breaker, no.
So you're, just to sum up your issues, obviously the porch and the deck are major
Yes.
concerns for you.
Yes, very much.
Your testimony was that there was some issue with the heat not working
And the AC as well.
and the AC not working. You said the plumbing was really bad,
Yes.
that the water, I guess you couldn't take a shower
Yeah, my
or a
son,
tub for a
yeah.
bath for a while.
Yeah. Or the sink in the bathroom as well would be flooded.
Okay, and something about a bathroom sink tub clogged.
Yes.
To which he gave counter testimony that he provided some evidence is to show that he had, looks like it made some attempts to correct the steps, and that's referencing some photos, but that took place multiple times, and it's one of them, the one that looks like it has some new fresh wood on the steps. That was August 2nd. To update those steps. Your argument is he updated the steps after August 2nd, which would have been after your latest fall.
Yes, yes.
And
Well, at least
then
5 days after.
And then, but didn't do anything to, allegedly didn't do anything to the front deck boards as cited in the rental inspection. That a yes?
Yes, that is a yes.
Okay. And then as it relates to the heat, you sent, or you just admitted some pictures that is about your thermostat.
Right.
And these were from February 17th. However, he has a receipt on the 19th. He sent someone over there, paid $418 to have a repair done in response to that. As it relates to the bathroom issue, I don't see any physical evidence or pictures or anything to discuss that, but we did provide some testimony evidence. He's provided testimony evidence about having service providers come out multiple times. And then also some testimony evidence about some foreign object or substance that was located in the drain. I can't remember, was it the bathtub drain?
Bathtub, Your Honor.
Bathtub drain. Or
And sink as well, Your Honor.
Okay, there's some receipts here from Michigan Drain from April 23. Another receipt from Michigan Drain, it says August 2022. Holt Plumbing, February 3rd, 23. This is for heat. His testimony today, though, would be that as it relates to the outstanding compliance for the inspection, the only issue that he believes has not been addressed would be a proper inspection and sticker for the water heater. Your statements would be that it should all, that the service panel still lacks labeling.
And the porch as well.
And then the porch. Okay. You submitted a bunch of text messages, but they've not been entered. I don't know if you believe that they should have been entered or that they were. I don't want you to believe these were entered because they were not. These have not been entered. And then you have some text messages, and it looks like urgent care, date of visit February 20th, 2023.
These are all the dates that I've fallen on the porch before the steps collapsed on me.
Okay, so when he submitted the picture of the steps being fixed on August 2nd, what year was that?
2023, when I was pregnant with my daughter.
Okay, you had I don't see, let's see here. I see on this urgent care receipt, it says the date of visit was July 17th, 2020.
Yes, I've been following on the steps for the past 3 years.
Right, but where's the receipt for your hospital visit after, or the 2023 incident?
It should have the wrist splint on there because I couldn't get x-rays.
Okay. I think the concern that I have with these medical records is number one, when you're submitting documents to the court, you don't get to write on them. You don't get to highlight any of the above. The other issue is that I have this urgent care receipt. It says page 1 of 1. And that's the one that says July 17, 2020. You submitted another page, which I believe is what you're purporting to provide, seen on July 2023 is what it says at the top. But that's page 2 of 3. Page 1 is missing for that.
Okay, then I think this may be it then. I think one of these, you said the July 30th and November 24th.
July 30th, 2023.
Yep.
You submitted page 2 of 3 for that medical record.
And this is the first one.
I don't have the first page.
This is the first one right here.
Supposed to be a 3-page document. And then there's a bunch of text messages with some pictures, but I don't know what evidentiary value you believe they hold. So I'm going to let you come and get these here so that you can see what you provided. And if you believe that they have evidentiary value, then you can go into that now. Otherwise, you can keep those and then we'll proceed to argument.
This is just me begging him to fix the steps after I fell for days and days.
After you fell when?
On July 29th.
Of 2023.
Yeah. I mean, it was days, question marks. I'm literally begging him to come fix the steps. And then when some person came, they brought the wrong wood and it was another 2 days. And I couldn't take my son to school. I couldn't go to work. I couldn't have people come drop off products.
And you're saying these front stairs are the only stairs for you to enter your home?
Yes, well, I have the back steps, but at that time I had a garden right there. So I couldn't, being pregnant, I couldn't move it myself. It was full of dirt. So that was my only, I don't ever go on my back porch. That's my only way of coming in and out of my house was the front porch. There's a gate right there. It was just too hard for me to move.
Okay. Anything else about those text messages that you believe show value to your case?
Just me stating that I'm begging him to come fix the steps, and why did they come? Where are they at? I have to get my son to school. I have to make money. I can't leave. I couldn't leave my house. I couldn't get down anywhere. Me asking him to fix everything.
What's everything? Are you
just
saying those text messages show you asking to fix something other than the porch?
Yes, the water heater, when I was like, my water light bill is so high because the water heater's leaking.
What date was that?
This is, I think these are all literally the same day or same week up to that.
I don't know what that is, what date.
It would be the month of July, 2023.
Okay, so you said in text message in July 23.
Yes.
About your report of water and light.
Yes, the water heater leaking, my water light being high. There's text messages about him missing payments and if I have any to send him. I admit that I can't go on the back porch. I can't lift the heavy gate with the bin of dirt in it. Can you please fix the steps? I asked him again, how long am I gonna be without steps? I'm pregnant, I can't get down, I still have a life, I still have to take Logan to school, my neighbors had to take him. And he just tells me, tell this all to the attorney. There's also me telling him about the permits that he was supposed to fix the deck and the breakers by that date, and he hadn't fixed them. The water heater not being fixed. Him not being in compliance with the city of Lansing. So I do believe that these all should be submitted.
Can you consider those to Mr. Long?
He also has a copy of those as well.
And so it's your argument that he does not currently have a valid rental certificate?
I think that when I called Meredith, he didn't have it that day, but she told me that he went there the next day and got one.
Okay. City records today show it's on hold. Do you have anything to dispute that, Mr. Long?
According to my client, the reason
I didn't ask what the reason was. I said, do you have anything to dispute that it's currently on hold?
any documentation,
Right, that he has a valid up-to-date certificate because the city website says it's on hold. Any other, or as it relates to those text messages, are you just objecting to those being exhibits? Or you can go over those with your client at any time?
I would just object to the ones that don't have dates on them.
So the objection is that, and I think it's reasonable, if they don't have dates on it, they can't serve to show when that communication took place.
This is the whole thread, so it never stops.
You know, if you get that from the
That's much better.
August 14th. This is all 2023.
Yes.
So you're saying this is the whole thread and it's being admitted in order?
I don't know if it's in order right now.
Yeah, because it's definitely not in order, because I'm looking at timestamp. Some say page 2 of this, the first 3 right here, all say page 2 of 3. Verse 4 say all page 2 of 3. So some things are missing. One page, where's the first pages are in all of these? I don't know that this is a conversation that goes in order.
Yeah, I don't know if it's in
So,
order at right now, no.
well, how am I supposed to read it and follow if it's not in order?
I can put them.
Just for example, this says, it ends with tell all this to the attorney. I tried to talk to you, so you didn't want to talk. So there, nothing to, and then it goes there, it doesn't finish.
Yeah, I have to put them in order for you right now if you'd like.
Okay. I'll let you put this in order.
Okay.
And then you can show Mr. Lum again, now that it's in order, and maybe his objection will change.
Okay.
Okay, Mr., you can be seated. Mr. Lund, you still have an objection?
I would just
Those are
reading my
separate.
objection for the ones I don't have dates, as well as.
Okay, so these are what?
One is focused on the rent payment that he's asking me, and then the other one is focused on strictly the steps.
Okay,
So
this
they
is
don't have times back to back because they're all a conversation.
Okay, so
you know?
August 14th is about the steps.
Correct.
It's August 14, 2023.
This is before I fell,
And you asked about,
or after, yes, after I fell.
I thought you fell in July 2023.
Yes, I meant to say after I fell. This is afterwards.
Okay, and you're referencing having permits on 4/15 and fixing the deck
Yes.
and the breakers and outlets by the date. That's what that's about, correct?
Yeah, but basically fixing
14.
everything that's going on with the house.
Okay, this is an ongoing conversation.
Yes.
The 14th, it's still on the 14th, but this can't be in order because this, well, maybe it goes to.
Some of them are
Descending.
screenshotted where I double take, you know, you can see the conversation and then I take another picture of the conversation beforehand as well.
Yeah, so the issue is that then there's no dates, and so if you have a camera roll, it should have the date that the conversation started, like this says the conversation started on August 14th. Then obviously this probably is part of that same conversation.
Yeah, after underneath it, yeah, this is the way that my camera was set up.
Right, but I at least can see that this says, this right here is exactly what this says. It's just. the
Yeah,
portion that got
yes.
cut off.
Yeah,
And then this has a date on it. This starts with okay, the last page ended with okay. The issue that I have then is. I don't know how this goes into this. I gotta have time. I have a baby OTW. I'm not about to move during that. And then it goes, I'm not going to keep paying 120 extra a month. I don't know if that's the same date because the timestamps are different. The time at the top of this. is
that's the time that I
1:46.
screenshotted it, I'm pretty sure. The time at the top in the corner. Yeah, those are the times that I screenshotted the
Yeah,
text messages.
so I don't know, I don't have any way of knowing that this is, that conversation flows in this, because you're talking about two different things. Talking about, I'm not gonna keep paying an extra 120 a month, and this was talking about having time to move.
It was me saying everything all in one. That's where all the text messages are. Me just complaining to him honestly.
I'm gonna grant this objection. I'm not admitting anything that doesn't have a date on it, because I don't, it's too difficult for me to try to figure out if these conversations align that way. Let's see. See, on this one, you're talking about fixing the porch, that's on July 30th, and then Monday, the 31st. And then there's dates of July 31st, August 2nd, and then it's August 2nd.
I guess it's just the way that my phone like screen, it doesn't show kind of on the iPhone.
Any other, and I'll admit these separately, since you're saying they report to discuss different things.
It's all really the same thing, him not fixing things in the
can
house.
do it in order, so these were all 2023, so it looks like it started in July, at least July 27th on these, and then that last page, that I need to admit is August 14th. I'm not going to admit those pages because I can't tell when that was. And so that would be people's score, I'm sorry, plaintiff's score. And then your urgent care receipts.
Oh, did you read the first one?
You had one from February 20th, July 17th.
Oh. That's good.
And then it was supposed to be one from July 30th, 2023.
This is the July.
This might be the first page. Does the first page look like this?
Yes.
I think it's out of order. That's the
The
issue.
July, is that for July?
July 30th, 2023.
Yes.
Okay. Let's see what you have there, Yolanda.
July 30th.
It might
No,
look
it
like,
doesn't look like my first page. Okay.
it doesn't look like that.
Okay, this is
The first page.
this is the first page.
Okay.
Okay. And you turned over a copy of these medical records as well.
Yes, to him and
Okay, so I'll have the medical records as plaintiff proposed exhibit 5. Any objection to the medical records? Yeah, I think that the missing page issue has been corrected because she provided the first page for the 30th of July 2020. That was what was missing for that. Well, that exhibit will be amended as plaintiff. I think that's the only other thing that we need. Some pictures of the home. Or bruises. Pictures of some bruises. I don't know who you sent these pictures to. That's Shelley. I don't know.
that's him when he had his, the other phone that he had.
Shelley is him.
Yes, those are him. He had a phone where he was sneaking to text me or whatever it was, a WhatsApp or text-free number or something like that. So those are all those text messages from
He
him
was
as well.
sneaking to text you.
Let's see.
What does that mean? He was sneaking to text you?
Like I said, we had a personal relationship for this and he's married. So-
Okay, you can skip him. Give her those so that she can look through those messages, because I don't know if it was your intent to have those admitted in some way.
The pictures?
Yeah, because there's pictures of some bruises and.
Yeah, but this is when I fell, all the times that I've fallen off the porch with this is the porch before it happened, the eaves trough that Mark fixed, that he wouldn't come out and fix. The nails, like the nails coming up on the porch for me falling in the porch completely.
Okay.
Yeah, these are all times that I've fallen on the porch where I went to urgent care.
Okay, you can show Mr. Long, you can make any objections he wants to.
He has a copy as well with these two.
Subject to the text messages that don't have dates on them.
I'll look at that as to the extent that they're not obviously a carryover to the same conversation. I'm not gonna spend time trying to figure out what dates those things happen. But to the extent that they have dates, I'll admit them. Yolanda, I'll do that. Yes. Okay, and I think that's all the proofs that I have in the file. And so I have your exhibits. I'm gonna include the admitted exhibits on this under your last exhibit, which is 5. And then, let's see, we have the defense A through correct, Mr. Long.
And this receipt from today.
I just attached it to the other receipt that he had already admitted for cooling, so it's part of E. Okay, so you can make your argument, ma'am, as to why you believe you should get recovery.
It's just that all the times that I've missed out on my business and just the stress of not, like the court, just my kids, not having heat and air for years. I've lived there. I mean, waking up freezing, having to get water heaters or space heaters, having him bring multiple ACs. I mean, he wants me to pay rent in a house that has central air, but I have window ACs in every single room to keep my house cool. You know, the water heater leaking, the times that we couldn't bathe, and it's just stressful because I love the home and I just wish that he would come and fix it. And it's not that he comes and fix it in a timely manner. I mean, it'll be days and days and days, and those things are important. And it's not just a crack in the window or the screen ripped or anything, things that I would fix myself in that home, but it's serious things. Like the porch is serious. And I begged him for years until I was pregnant and fell down the porch, and then he had to do something, and he still didn't do anything within the 24 hours or 48-hour period. It was still days afterwards that he had somebody come, and they were smoking on the job, and it's just like, how did I know that the steps were put in properly? You know, it was just it was just depressing and stressful the whole time I've lived there. And it's a great home, and it has great potential, and I love my area, I love my neighbors, I love the house, my kids love it, they were raised there. So it's just, I wish that he would fix things. I mean, the drain problem is back to back to back to back, to the point where even the drain company came in, was like, he's gonna have to put in some money that he really doesn't want to do underneath here with the pipes. You know, it's just kind of being cheap about things, you know?
If you're having all these issues, and it's major issues, as you stated,
yeah,
for years, and it's causing you stress of this magnitude, why would you live here?
Because they're things that I know that he can fix. It's just,
that doesn't mean, just because you know that they can fix it doesn't mean it. So why would you stay here?
I love the area. I love my neighbors. My kids go to school right down the street.
Find another house in the area. Why would you do that? How do you think that this landlord-tenant relationship is sustainable?
If he were to fix the porch and the drain, I'd be fine. Those are the only, in the air, I'd be fine. Those are the only main things that I would like him to fix.
You want to fix the porch and the drain, and you said you'd be fine.
The porch, the drain, and the
like
air.
you said, and I don't know because it's hearsay and it wasn't admitted, but let's say, for example, there was a major drain issue, which is common in this city. It could be an issue because of plumbing going into the piping, who knows? Well, let's say that's the case and it's major, it's gonna cost him a lot of money, and he doesn't want to put that money into getting new plumbing done. What are you gonna do?
Well, Mark has actually snaked the drains so that the drains work better than they have before. So the drain, the snake, now I have my own snake where I can do it myself if it were to be plugged.
Okay, so the drain issue's not a major issue because you snaked it.
The air is the issue. The
AC,
air in the porch.
the fact that there's no central air is a major issue for you.
In the porch, the wooding coming up.
Yeah, the porch is something that was cited by code compliance.
Yeah.
They're not citing air conditioning, because you know why? It's not a major issue, that's the luxury. We don't have to provide you central air.
The heat in there, I think.
Heat is different,
Yeah.
but AC, no, we don't have to provide you central AC. You have some units that you can use in your window, like you said. Heat, you need heat.
Yeah.
And so, but if the representation is that he's kept this home in such disrepair that it's interfering with your enjoyment of the home or your use of the home, that it's not fit for the use it's intended for, then I don't know how you can, in the same sentence, say that you love the home.
I do, with all of it, even I do. I love the home. I put in work to it myself. It's just those two things that I feel like he should fix, and I would be fine. It's not like I'm asking for a lot. I mean,
well, if that's the case, what are we doing here? Why don't you all negotiate this outside of here? You fix this and I'll drop the lawsuit. Why don't you all do that?
It hasn't been fixed. I'm not sure why.
Okay, Mr. Levy, you can make the argument.
Your Honor, it's the plaintiff's burden to prove all the elements of a legal claim to establish damages. I believe Ms. this church has proved all the elements of the legal claim, which would be duty, breach of that duty,
I don't believe
causation,
she proved breach of a duty to repair the stairs
and damages.
and damages. You don't believe that?
I don't believe she's ever given us a number of damages that she's.
Well, we can hold a whole separate hearing on damages though, and you know that. But she just has to prove that she suffered some damage. The court can evaluate the damage themselves.
To the extent of a personal injury claim prior to August 2nd, 2020, I would argue that prior to that is required by the statute of limitations for personal injuries.
Is there anything prior to August when?
August 2nd, 2020, 3 years prior to it's been filed.
I agree.
My client, when he's been notified of repairs, he's done his best to get over there and make those repairs. As evidenced by multiple receipts. Plaintiff needs to notify the defendant of any repairs that need to be made. This is my client's position that she hasn't met all of the elements of the legal cause of action. We ask that. And
Thank you. Any further argument from you, ma'am?
No, Your Honor.
Okay, so you filed a civil action claiming some damage. I think you were seeking recovery in the amount of $15,000, I believe is what stated in your complaint. You said you wanted to relocate. And you said but you did say that you wanted to relocate because he would evict you because of this cause of action.
Mhm.
Maybe you are not aware, but the law does protect you from retaliatory eviction. And so, yeah, the law protects you from a retaliatory eviction. So there is a presumption, I guess, of an eviction. If you go home and next week you get an eviction on your door, there's a presumption that because of the time frame, it's likely retaliation. Doesn't mean that you can never be evicted. Also doesn't mean that you don't pay your rent.
Right.
And that presumption is not going to grant you, any kind of indemnification to stay in his property forever. I don't, just listening to this and seeing how this case has played out over the 2 days that I've seen you all, I don't even know how or why you would want to stay in his property. I don't know how it would be healthy and beneficial to you as a mother and someone who's in a relationship to be in a home where you've indicated you've had a relationship with this individual, the intimate nature. You should probably want to pack your things and sever that relationship and give him his property back. I don't care how much you love the home. There's plenty of homes in the city of Lansing that look like that home. And so, but to say that he's caused you this amount of stress and then present evidence to show that not only has it caused you some stress, but to show that you've had some supposed injuries because of the lack of repairs to the property, it just doesn't make sense to me that you would continue to want to be in that environment. Nonetheless, you're alleging damages from a fall from the stairs or multiple falls. Again, you indicated that you fell February 2020, July 2020, and then that you fell on July 30th, 2023. Again, as indicated by Mr. Lum, there's a statute of limitations on certain claims. Do I believe that you sustained or presented enough evidence that will sustain a burden as it relates to the fall? I absolutely think you did. You demonstrated via text messages that you made communication multiple times about the stairs, almost to the point where it appeared she's begging in these text messages about some stairs being fixed. There has been evidence submitted both by the plaintiff and by the defendant that shows pictures of the stairs, and the plaintiff presents pictures obviously very different from the ones that were presented by the defendant. The plaintiff shows pictures of after the fall that shows wood that is clearly deteriorated, and there's a whole step that appears to be missing from the top of those stairs, and the nails that have or won't even be, they wouldn't, there's nothing that could be done with this wood and these nails based on what I'm seeing to cause these stairs to be put back together. There was some testimony from your witness, Mr. Carmack, that he did make some attempts, I guess, to fix the stairs or the gutters or something to that nature. The defendant did submit an exhibit and testify that on July 29, 2023, that there was an attempt to fix the stairs. And the court can see even in the photos where after this repair took place, there's some rusted loose nails there. And then it appears that even after this has been replaced, that there's just gross deterioration to the integrity of this wood. And that was what was supposed to be your repair on August, or so July 29th. And so now there's allegation that after that she falls on the 30th. Now we get new wood. Now we fix it so that she doesn't fall. Well, just put on notice beforehand multiple times. What about these stairs? Wasn't repaired. She uses the stairs. She falls down. He's liable. How much he's liable for? I don't know. I don't have any medical bills. I don't have any records here that shows me that she had a loss of wages, that she had to go to get any treatment, any physical therapy. None of that has happened. I'm gonna have to set this for a whole nother hearing for her to present some kind of evidence, because all I have now is that there was a fall. And I believe that the fall happened because the stairs were in disrepair, because I have multiple pictures showing me that. And then I have pictures in text messages that show the bruising, as well as medical records. The medical records, although I've agreed with the defense that there's a statute of limitations on the previous claims for falls in 2020 because of the statute of limitation. But we have pictures of bruises and stairs after that she's sending to him to show that there had been a history that expanded 3 years regarding these stairs. That's ridiculous. Stairs could have been fixed for very little money. And responding to a request from your tenant about stairs being fixed to, well, are you going to pay your rent? That's a separate issue. She does need to pay her rent, but you need to keep your property in repair regardless of if she pays the rent. If you don't keep your property in repair and a delivery person, that let's say the mailman comes to walk up those stairs and he falls, you're liable. Doesn't matter that she didn't pay her rent. You're supposed to keep it in repair. And it's not just for her consumption. It's reasonable that somebody could come and deliver something and fall through those stairs. And then now you created a risk of liability for yourself because you didn't want to fix the stairs because she didn't pay the rent that you thought she should pay repair. As it relates to the air conditioning, and it's unfortunate. It would be nice to have central air. I don't know. You've not presented me a lease that said that was part of your lease agreement. You're just telling me that the place was supposed to have central air. It's broken. He didn't fix it. I'm not sustaining that cause of action because I don't think it's necessary for your rental conditions. Heating, however, is a necessary issue. I did see some text messages about the heat. I see obviously the way you presented evidence in your exhibit regarding the temperature in the house. However, he's provided the satisfactory evidence to support that he sent somebody to take care of that heat, at least in 2022. And then again, 2 days within 48 hours of one of the pictures that you sent. I was going to say, I don't know, or I don't know that your pictures show me that you sent them to him because you told me you don't have that phone, but the date on this is within 48 hours of that date. So it's reasonable for the court to conclude that he received those text messages and then responded by sending someone out to have the heat replaced. And then I don't see any communications or any screenshots or pictures after this date showing that, well, we still didn't have heat even after this happened. And you're saying that no one appeared. Maybe someone appeared and you weren't there and they just failed to tell you notice we sent someone to get it fixed. I don't know. He got a receipt. He paid $418. This is the services that was provided. And it was for the location where you live, and you haven't provided me anything that rebuts this by saying, well, even after February 19th, I still didn't have heat. This is where I told him on February 20th, no, the heat still is not working. This is where I told him in March, hey, it's snowing outside. You've not provided me any evidence. Typically when I get cases where people are saying I don't have heat, well, what happens is they wouldn't got a hotel room while the heat was being replaced because they got kids and they couldn't stay warm or whatever the case is. And they bring me those receipts, something that shows me that you suffered some damage. So you have to have, it can't just be a duty and a breach. There has to also be damage in order for you to get a cause of action. So as to whether or not you had an issue with getting heating, I believe you did, but I think he cured that issue within the reasonable time under the statute, within 48 hours, which is reasonable to get that heat addressed. I have multiple receipts from a drain commission. I think that there's been an ongoing issue, just as much as there's been an ongoing issue about those stairs, about this drain. And I see where he's spent some money and sent people out multiple times. You didn't call any witness or the person that you said told you that there was a bigger issue. There may be a bigger issue. I don't know. But I also heard your statement that you have found that snaking the drain is beneficial and has caused there to be better drainage. And they're likely, I don't know if you have large trees on that property. I don't know if there's roots that are going into the drain. I don't know. But I have testimony from the defendant that that there's been some discussion or some issue in the past about putting some substance, rocks or something, I don't know what it is, into the property and how that likely could have caused some backage of the drain. I don't know whether that those are things the court can consider, but I don't know if that's the case or not. Drainage can be slow for a number of reasons. You got a lot of hair on your head.
Yeah.
I'm sure your children probably have a lot of hair. That could back it up. I have to snake. I have curly hair. I have to snake my drain sometimes too. It happens. It's just a nature of what's happening. But you're not presenting me anything that shows where the conditions of the drain have been such that it causes the use or the fitness of the property to be below the standard. And I have evidence where he has sent someone multiple times to address the drain issue. So I'm not going to sustain a cause of action for that. As it relates to a compliance with the law for the certification and the code compliance issue, I think he's conceded. Maybe I haven't gotten the sticker. The city website indicates that he's not, that his certification is on hold as of right now, probably because he hasn't gotten the certification. It sounds like he did get a new water heater, just didn't get it properly inspected so that the city can be satisfied. I don't see where they've been back out to that property where they've red tagged the property or peak tagged the property. He does need to get that issue addressed. But obviously there's a new water heater there, no? So that means he's been doing something to try to maintain that issue. And then there's a issue as it relates to the breakers not being properly labeled. I don't believe he was aware maybe, or he disputed that. It's clearly stated here that the service panel lacks proper labeling at the breakers. And if that's the case, it needs to be done, but you not showed me where, and that, so there is a duty there, but you're not showing me where that caused you some damage because he didn't do it. You have to show me where, because he didn't do it, you suffered some kind of loss, monetary or physical of some sort, because he didn't do those things. And that's not the case here. It's just something that you can hold over his head. And to the extent that he doesn't get it done, I guess code compliance can come back out. But if they pink tag or red that property, then you gotta go. So I'm not gonna sustain a cause of action for that. The only cause of action I'm going to grant you is on, or as it relates to the slip and fall. Because you did give prior notice according to the law of the issue. He acknowledged notice of that issue in some of these text messages. It was not properly addressed, and because of that, you fell. Now, I don't know what the damage was. You have not presented any medical bills that you have paid. You've not presented any evidence of what your loss of wages would have been, but that you could not sustain that. You could not get that money because of the injury that you sustained.
I find receipts.
You've not, you provided those to Mr. Lum.
To both of them, to both of you.
Receipts as to what?
Yeah,
Everything that I have, I gave you back, so I don't have any
Yeah, it was
receipts.
like missing, like I do placenta encapsulation, so all my business receipts that I had.
Business receipts. Okay, so
Yeah.
I'm gonna hold a separate hearing for that because it's 107. I have another docket that's coming in, and it's not your fault that this other docket carried over, the interpreter was late. But I'm going to actually require that you have a conversation off the record with Mr. Lum. You all can do it today if you'd like, so that you can go over these receipts and see if you can, to see if he has any dispute. If not, if he is going to, if you all want to concede on an amount or agree to an amount, consent to an amount for what you believe her loss was or her damage was. You're not getting $15,000, and I don't, unless you could show me that you broke your leg and you had to have some surgery or something, or unless you got some receipts in there that show me that you would have made $15,000. Your requesting, your summons was that you wanted $15,000 to relocate, not that you suffered a loss of $15,000. That you wanted that so you could relocate because he was going to evict you because of this lawsuit. Eviction and where you live after this is not before the court, but I don't know how you all are going to work this out. Other than at some point, you're going to probably want to find or make other arrangements, because I don't see this getting any better. But that's between you all and not before the court. So I'm going to give you a date to have a hearing on damages because Mr. Lum does not appear to have what you believe or you purport to support your damages. You have that, Mr. Lum?
The only things I have are the three receipts.
Yeah, you're gonna need to provide him with some financial records. I don't know if you had medical records or co-pays that you had to pay, if you had to go to any treatment, but you need to provide him some authentic records as to the loss, financial loss that your work or business would have suffered because you fell. And you have to be able to show that it was because you fell. Okay? Because you can still get a cause of action and it's for $1. Okay, sounds good. Let me get you a date.
September 4th at 3.
September 4th at 3. Does that work? I know that's right after the holiday. Yeah. You need another day, Mr. Long.
Yeah, I have a poison. On that day. I have 2 or 3.
Okay, we'll get another day.
September 9th at
The September 9th at 2 work. Need something in the morning?
Yes, Your Honor.
Like what time in the morning?
Kid drop off is 9 a.m. I'm free after 9 a.m. Your Honor.
Do you have anything with the dinner? Or not for a while? 18. Well, he said after 9:30?
Yes, please.
Yeah, so like 10,
9:30 is fine.
9:30? I can ask. Okay, one what day? September 18th at 9:30. Okay, any additional matters for today's record? Don't forget to exchange your records with him so that you all can have an off the record discussion before you come in here. Okay. You're all set. We'll get your notice to appear.
Do you all have time to do it now?
Actually, no, I have to get my son, but tomorrow or within this week, I think.
Okay. For the course of action, do we still need to make that date or can we submit?
Yes, if your attorney could submit me a consent as to that amount, you do not need to appear. I'll sign it.
Okay, thank you.
Thank you.
So wait for your, Mr. Hicks,
Hearing on damages.
would you guys like to wait for your